advocate for a client, but here's the thing. He put himself in a box when he said, my client's damaged.
To get a search warrant, you have to have probable cause that a crime's been committed and there's evidence in a particular place.
Knowing what a prosecutor must prove on the charge of burglary is critical when understanding what it is and also how to defend it. See, burglary could be a second-degree crime with exposure up to 10 years in prison, could be a third-degree crime with up to 5 years in prison, and it could be used as a predicate act in the domestic violence context for a final restraining order. See, at the Bianchi Law Group, we handle criminal defense, domestic violence, and municipal court cases. So oftentimes, we represent individuals charged with burglary. The first thing that we do when we're retained by our clients is we give them a welcome package with the statutes and also the criminal jury instructions. You see, the criminal jury instructions are a set of instructions that go to the jury after a jury trial in the Superior Court when a defendant faces the trial of their lives revolving around burglary. Now, burglary is defined in the statute, but jurors, they don't know that. They haven't been to law school. They have no extra training. And we as attorneys have to make arguments to the court as to what jury instructions need to be given to the jury so they could decide whether or not a defendant is guilty or not guilty. As prosecutors, we use jury instructions. And at the Bianchi Law Group, we use those jury instructions to provide to our clients to give them an understanding of what are the elements of the crime and what has to be proven. You see, you need to know what has to be proven to effectively help your attorneys and ultimately, hopefully, win your case. See, the stakes are high. As I said, the burglary could have up to 10 years in prison if convicted. You, as a charged defendant, must understand what that exposure is and understand what needs to be proven. It's important when considering whether or not a plea is reasonable or whether or not you exercise your constitutional rights to go to trial. My name is David Bruno. I'm a partner at the Bianchi Law Group, located in Parsippany, New Jersey. We are a team of former prosecutors who aggressively fight the government when our clients are charged with crimes. Not all prosecutors are equal. I was a prosecutor in the homicide unit, in the major crimes unit of the Morris County Prosecutor's Office. My law partner, Bob Bianchi, was the head Morris County prosecutor appointed by the governor and unanimously confirmed by the Senate. We left the prosecutor's office in 2013. We formed the Bianchi Law Group, and we have since expanded. All of our associates, senior trial attorneys, they are all former prosecutors with jury experience. You see, as prosecutors, you learn how to prosecute cases with the ultimate burden of proof beyond a reasonable doubt. And that's all you do. You stay in one court, in the criminal court, prosecuting cases over and over again. So you learn, you cut your teeth on the criminal code, and at a very young age, you could try cases. I personally tried my first homicide case at the age of 27. But as prosecutors, you get to learn how to put cases together. So we found it valuable at the Bianchi Law Group to exclusively hire only former prosecutors. In fact, our paralegal is a former law enforcement officer that also understands how the code is prosecuted. Let me tell you about John. John is a former client of the Bianchi Law Groups. John spent 210 days in jail prior to hiring us. You see, his first attorney did not know the elements, did not know the definition of serious bodily injury, and did not understand that the prosecutor could not prove a second-degree aggravated assault charge that held John in jail for 210 days. We got in the case, reviewed the evidence, reviewed the medical records, compared it to our law and definitions, and shortly found out that it couldn't be proven. Got John out, and we got him a good disposition. It was pretrial intervention on second-degree aggravated assault charge. So let's review the elements of the burglary using the model jury in charge, as I said. So I will share my screen here, open up the second-degree burglary. As I said, this is the second-degree burglary that exposes a defendant up to 10 years. But it starts off with the third-degree burglary. Why? Because the second degree has these additional elements that we will review in a second. But first, the third-degree burglary. A person is guilty of a third-degree burglary with the purpose to commit an offense therein. The person enters and it depends on what it is, structure, we'll go with structure, or a separately secured or occupied portion thereof, unless the structure was at the time open to the public or the person is licensed or privileged to enter, or surreptitiously remains in a structure or a separately secured or occupied portion thereof, knowing that he is not licensed or privileged to do so. But what gets lost in this interpretation is this line: with the purpose to commit an offense thereof. So that's the difference between a burglary and a trespass. If you're just merely on a piece of property without license to do so, with no intent to commit a crime or an offense in it, well, then it's a trespass. But here it's got that additional element, purpose to commit an offense. That could be a crime, it could be an offense. So let's just say that an individual is breaking into a home to steal property. That is a third-degree burglary, because the person is, with the purpose to commit a crime therein, enters the structure that was not open to the public, and he's not privileged or licensed to do so, right? But what makes that burglary a second degree? And we look to the jury instruction for that as well. So that person is guilty of burglary in the second degree if, in the course of committing the offense that I just described to you, that person purposely, knowingly, or recklessly inflicts, attempts to inflict, or threatens to inflict bodily injury on anyone, right? So that's a situation where they may run into somebody and there's a threat or there is infliction of bodily injury that that brings the third degree up to the second degree. Or if that person is armed with or displays what appears to be explosives or a deadly weapon. So there's a lot of definitions that are in those elements that I just reviewed with you. And all of those definitions are located in the jury charge itself. This jury in charge, I will put a link in the description of this YouTube video for you to download this yourselves. Additionally, we'll also put a link to our ebook written by a team of former prosecutors about understanding the criminal justice system in New Jersey. If you've been charged with a crime or an offense, download that ebook, because it will go over with you everything to expect from arrest to final disposition about your case. If you have any questions about that, give us a call at the office, 862-210-8570. Go to the website, bianchilawgroup.com. So just as I go through, talks about purpose to commit an offense, defines structure, talks about the purpose, the state of mind is a condition of the mind which cannot be seen and can only be determined by inferences from conduct, words, or acts. This is the language right here that the jury gets. Oftentimes when I'm closing in front of a jury, I will parrot the language. I will tell them, this is the law. And then when the judge starts to read the jury, the instruction, I sit there and I get looks because now I am a source of credibility in the courtroom, showing them what the law is before they even hear it. But we do that at the beginning of the case with our clients. It's important not only that the jurors get this and that the attorney understands the law, but the client needs to understand the law to be able to help in his or her own defense. All right. So as I said, critical to understand what needs to be proven. As I just went over with you what the elements are, it can put you in the position to either help your attorney or properly evaluate the case, whether or not it should be pled or you should go to trial. I hope you enjoyed this video. If you stay on at the end, you'll see the next video, which is Bob Bianchi, my law partner, the former Morris County prosecutor, talking about what to look for when choosing a criminal defense lawyer. And I'll give you a hint, the Bianchi Law Group. Why? Because we're a team of former prosecutors. We are certified. Our partners are certified criminal trial attorneys by the New Jersey Supreme Court. Our core values are courage to stand up to our adversaries, stand up to the courts, compassion to help our clients in their worst times, to get them through this process, and the commitment to our file, the commitment to our clients, the commitments to file motions, and the commitment to squeeze every last drop out of anything that we could possibly get for our clients in their case. If you have any questions about this video or anything else, don't hesitate to contact us. The links are in the bottom, and you can call us at any time, 24/7.